everyone, and welcome to our webinar. My name is Kate Redshaw, and I'm a lawyer in the employment team here at Burgess Salmon. And we're delighted to have you with us today, particularly as we know so many of you will be juggling at the moment with homeschooling and other calls on your time. We're really pleased you could make it. So if you normally join us for our Hot Topics session, you'll know that our approach is to make sure we give you a heads up of all the key employment law developments, and that's what we'll be doing today. This does mean we'll be covering a lot of ground in a limited amount of time, but fear not. In the next few days, next week, we'll be sending out the slides, a detailed handout and a link to this webinar so that you can watch on demand. So let's have a look at what we'll be covering today. Now, despite COVID, the courts and tribunals have been continuing to operate, albeit in a reduced capacity. So we do have a roundup of the key cases. We'll then move on to our trending topics. We had to cover COVID, of course, but how to do that concisely was a bit challenging. So what we've opted for is to answer the top questions crossing our desks, and I hope you'll find that useful. We'll then look at Brexit, both in terms of what it means from an immigration perspective, if you want to recruit employees into the UK, but also the employment law implications too. And we'll round off our session with a look at the key cases on appeal that you can expect to hear more about this year, and also a look at upcoming legislative developments. So, without further ado, I'm delighted to introduce our speakers for today's event. We have Adrian Martin, our head of unit, and a well-known name to many of you. And joining Adrian today will be one of our associates, Molly Horton, again, a familiar face for many of you watching. Adrian and Molly will be speaking for about 45 minutes or so, and then we'll move on to questions, finishing up at 1 o'clock. So, Molly, over to you.
Thank you very much, Kate, and good afternoon, everybody. So we're starting off today with a couple of cases concerning redundancies, something that will unfortunately be on many of your minds at the moment, I'm sure. We're going to be going straight in at the deep end with the case of UQ and Markleen Technologies. So, as you'll know, when you're proposing to make 20 or more redundancies in a 90-day period, you must collectively consult with affected staff. So how do you work out if you've hit 20 or more redundancies in 90 days? And which 90-day period should you even be looking at? This requirement derives from EU law, and recently the European Court of Justice was asked to consider just this. The case was referred by the Spanish courts, who were dealing with a situation whereby an employee alleged that their dismissal had been one of a number of covert collective redundancies that had been carried out without proper consultation. The Spanish courts asked, in considering whether collective consultation was triggered for a particular redundancy, whether the 90-day period ran backwards from the date of the dismissal, forwards from the date of the dismissal, or was a rolling 90-day period spanning either side. The ECJ held that the 90-day period is a rolling period, and if the threshold is met at any point across that 90 days, then collective consultation will be triggered. This means that when assessing at a particular point in time whether you've hit 20 or more redundancies in a 90-day period, you need to look at dismissals that took place before and dismissals that are proposed to take place afterwards. If the threshold of 20 or more is met at any point, then collective consultation is required. So let's say you make 10 redundancies on the 1st of March. You haven't made any redundancies in the past year, and you're not planning to make any more, so you do not collectively consult with those individuals. Unfortunately, business doesn't improve, and you find yourself considering 15 more redundancies in the middle of May. Whilst neither of these groups exceeds 20 people, the rolling 90-day period means that collective consultation obligations apply to all 25 staff. Now, whilst you might be able to anticipate this for the May batch, taking into account those earlier dismissals, this might leave you in a tricky situation with regards to 10 individuals who've already left. Now, this might look like a pretty unsatisfactory situation, but one thing to note is that the UK legislation is very much forward-looking with a focus on upcoming proposals rather than what has gone before. So it may be that the impact of this decision in the UK is somewhat limited. In the meantime, the key takeaway from this case is that careful planning will be needed when you're staggering batches of redundancies, particularly if you're looking to stay outside of collective consultation thresholds. It would also be helpful to document your thinking throughout. So if you genuinely aren't planning further redundancies at a certain point in time, you can evidence this should the position change later. Watch out for smaller pockets of redundancies that might tip your whole exercise over into collective consultation territory. And if you have lots of redundancy activity taking place across the business, consider setting up a central log to monitor your numbers. For our next case, we're going to stick with redundancy for a moment and look at the case of Gwynedd Council and Barrett and Hughes, which considers when, if ever, you can use a competitive interview process to select employees for redundancy. Now, you'll all be familiar with the usual process of carrying out a redundancy exercise. Employees in similar roles are pooled together and scored against objective selection criteria, with the lowest scoring being made redundant. When then can you dispense with pooling and selection and go straight in with a competitive interview process to decide who to retain and who to dismiss? In Gwynedd Council and Barrett and Hughes, the claimants were PE teachers in a school. Their school was closed and a new one was reopened on the same site. Rather than pooling and scoring the existing staff, the council decided that all teachers would have to apply for roles in the new school, and if they were unsuccessful at interview, then they would be made redundant. The claimants were unsuccessful at interview and were dismissed. They were not given the chance to make representations about their dismissal, nor were they given the right to appeal. They were held to have been unfairly dismissed. The courts here took issue with the fact that the claimants had essentially been asked to reapply for their own jobs. The EAT confirmed that whilst a competitive interview process can be used in a redundancy scenario, it will likely only be appropriate if the interviews are for new roles. Competitive interviews should not normally be used where the remaining roles are the same or very similar to what the employees were doing before. In that situation, it's still normal and best practice to carry out a pooling and selection exercise. In this case, because the roles were effectively the same, the use of a competitive process and the lack of the appeal made the dismissals unfair. Now, I know that many of you may want to undertake competitive interviews as part of your redundancy processes. So where you're undertaking a restructure, for example, and roles are being combined into new jobs, then competitive interview may well have an appropriate place to play in that kind of exercise. However, if you're making a straight headcount reduction and remaining staff will be carrying on largely as they did before, then pooling and selection against objective criteria is still likely to be the most appropriate approach. If you want to use competitive interview, think about how you can demonstrate the differences between the old and the new roles to ensure that the interview process is genuinely forward-looking. I would flag that this decision is currently subject to appeal, so we'll wait and see if the Court of Appeal agrees. Moving on to our next case, we're now going to look at a couple of cases concerning disciplinary processes. In this case of Ty, Terrarian and Christie, it concerns a question that I find comes up quite a lot. When can you rely on anonymous witness evidence in a disciplinary process? In this case, the claimant worked as a carpenter for a housing association and was dismissed for misconduct after a tenant reported that he had made homophobic comments. The tenant gave their witness evidence anonymously, and the employer relied on that evidence in deciding to dismiss. Now, in a misconduct dismissal, in order to dismiss fairly, you must establish that you have a genuine belief in the misconduct, that belief is based on a reasonable investigation, and the decision to dismiss is fair in all the circumstances. In this case, at first instance, the tribunal initially found the dismissal to be unfair, but this was overturned on appeal. The Employment Appeal Tribunal thought it was possible that the employer could have had a genuine belief in the misconduct, even though it was based on anonymous evidence, and that relying on that evidence could potentially be reasonable, and the case was sent back to the lower courts to be reheard. Now, as I said, anonymity of evidence comes up quite frequently in disciplinary investigations. So whilst this case is really helpful in confirming that relying on anonymous evidence is not in and of itself unreasonable, you should still exercise a degree of caution when agreeing to grant witness anonymity. The desire of a witness to be anonymous needs to be balanced with the right of the employee to understand the case against them and to put their side of the story across. Careful thought needs to be given as to whether a fair process can be carried out if the evidence is anonymous. If it's impossible for the employee to respond to the allegations or challenge the evidence in a meaningful way, then that might render the process unfair. I would suggest exploring with witnesses why they want anonymity and seeking to address their concerns if you can. Bear in mind that the credibility of that evidence might be affected by anonymity, and you should also make clear that you can't guarantee anonymity completely in any process. In our next case of Udine and London Borough of Ealing, this concerns a situation where new information comes to light after the disciplinary investigation has concluded, but before the final decision is made. Again, I find this comes up quite frequently in practice, so it's really useful to have some PL level authority on this point. In this case, the claimant was dismissed for misconduct on the basis of an allegation of inappropriate sexual behaviour towards a colleague in a bar. During the course of the investigation, the alleged victim made a complaint to the police upon the urging of the investigation manager, who was a former police officer. After the investigation had concluded and found a case to answer, but prior to the disciplinary hearing, the employee withdrew her police complaint. The investigation manager knew that the complaint had been withdrawn, but they did not tell the disciplinary manager about this. The disciplinary manager took into account the fact that there was a live police complaint when making her decision. The tribunal dismissed the claimant's claim of unfair dismissal, but the EAT disagreed and reversed that decision. The EAT said that the tribunal had wrongly equated a situation where a complaint had never been made to one where it had been made and then withdrawn. Because the dismissing officer had taken into account the fact that the police complaint had been made, the failure to inform her of its withdrawal rendered the dismissal unfair. The EAT thought it was possible, based on the evidence, that the dismissing officer would have drawn conclusions from the fact that it had been withdrawn. Bearing in mind the really serious allegations against the claimant and the significant impact upon him, the process had not been fair. The EAT has helpfully concluded that the involvement of the investigation officer does not end at the point that they submit their report, and that the tribunal must consider fairness of the process end to end. Fairness in this case meant taking into account the new information. Now, this principle will apply to all new information that comes to light during the course of a disciplinary process, and you cannot close your mind to new information after the investigation stage. You should make sure that everyone taking part in the disciplinary process understands their responsibilities and enable information sharing to occur. I'm now going to pass over to Adrian to take us through our next cases.
Thank you, Molly, and hello everyone. And can I say first of all what a pleasure it is to be talking about employment law rather than helping my daughter with her maths homework or maths lessons. I feel much more at home on this topic, which I'm pleased to say, and I'm sure you will be too. So the first case I'm going to look at is about justifying indirect discrimination and whether saving costs can ever be a factor in a justification argument. In this case, the claimant worked for the probation service, and in 2010 the government had introduced a public sector pay freeze because of the financial crisis. And in response to that, the probation service introduced a new pay progression policy that reduced the number of points that employees went up by. And it went from 3 points a year to 1 point a year. Now, this led to a claim for indirect age discrimination by the claimant, who was a younger employee. And he said that the change meant it would take 23 years to go from the bottom of the pay scale to the top, whereas previously it would have taken 7 or 8 years. He argued that that provision therefore disproportionately impacted on younger employees and thereby constituted indirect discrimination. Now, it's a defence to a claim of indirect discrimination to justify the treatment, and the probation service looked to justify this new policy. In order to do that, they had to show that it had a proportionate means of achieving a legitimate aim. And in this case, they said that the legitimate aim was living within its means as it had a finite budget. The key issue was therefore whether this could constitute a legitimate aim, because it's well established in both European and UK case law that saving or avoiding costs will not on its own amount to a legitimate aim. You have to have something more within your aim, and that's led to this being referred to as the cost plus rule. Now, in this case, the Court of Appeal said that the essential question is, can the employer's aim fairly be described as no more than just a wish to save costs? If that is all the aim amounts to, then it will not be a legitimate aim. But if there is more to the employer's argument, you'll need to decide a fair characterisation of the employee's aim as a whole and decide whether it was legitimate. In this case, given the constraints under which the probation service was operating, its justification defence was upheld. Now, this is obviously a helpful case for employers because limiting or saving costs or operating within a budget will form part of obviously a huge number of decisions and policies. And so it would have been very difficult for employers if cost could not be taken into account in this way. However, it remains clear that simply trying to save costs will not be sufficient, and it will be necessary to have additional factors, such as the need here to live within clear financial constraints. So although the Court of Appeal didn't like the cost plus label, effectively that is what the position is, and the Court of Appeal effectively confirmed that that is the position. Moving on to the next case, this looks at when the protection in the Equality Act against gender reassignment discrimination will be triggered. You may well have seen this in the news reports because this involved Jaguar Land Rover, obviously a well-known brand, and they publicly settled the case for £180,000. So it did attract some headlines. Now, in this case, the claimant had described herself to her employer as gender fluid and transitioning, but said that she had no intention of undergoing gender reassignment surgery. And the question was whether this brought her within the scope of the Equality Act. We've set out the relevant definition from Section 7 of the Act on the slide, and I've underlined the key sections. So what the section provides is that a person has the protected characteristic of gender reassignment if they are proposing to undergo, are undergoing or has undergone a process or part of a process, and that reference to part of a process is important, for the purpose of reassigning the person's sex by changing physiological or other attributes of sex. And again, that or other attributes of sex is also important. As I said, the claimant here was not looking to undergo surgery, but she did want to live as a woman rather than a man. And the big issue that sort of sparked this was actually her wish to dress as a woman at work. So what did the tribunal held? Well, they held that the claimant was covered by the protection. And I think there are two key points from the judgment. The first one is that the tribunal held there does not need to be a medical process for the protection to apply. And secondly, the tribunal described gender reassignment as a spectrum, moving away from birth sex, and said that it can therefore include individuals who describe themselves as non-binary, gender fluid, or transitioning. This is actually the first time that a tribunal's had to consider this point, and although it is only a tribunal decision, the key point is that gender reassignment protection may well apply to individuals who present themselves as being non-binary or gender fluid, rather than those who are actually undergoing a medical process. So it will be necessary to treat them appropriately. Now, this can be a difficult area, and the judgment, which is available online, gives some useful guidance for dealing with someone who is transitioning. So it would be worth looking at if you're dealing with a similar situation or if you're reviewing your policies in this area. Although I would warn you that the judgment is quite long, but it probably is worth a bit of time if you're looking at this area in detail. Okay, moving on to the next case. I'll deal with this fairly quickly because it's a Supreme Court decision in a long-running dispute that I would imagine you're already aware of. But this is the case of a disgruntled employee of Morrison's supermarket who posted payroll data for the entire workforce online. Obviously a very significant data breach. In fact, it was so serious that the employee was arrested and convicted of criminal offences. But what this claim related to was a class action by employees, I think about 9,000 of them, claiming that Morrison's should be vicariously liable for the employee's acts. Now, as a quick reminder, vicarious liability is where one person, i.e. Morrison's here, can be liable for the acts of another, i.e. the employee. In the earlier decisions, both the High Court and then the Court of Appeal had held that Morrison's was liable, even though they'd acknowledged that Morrison's had effectively done everything it could to avoid a data breach of this kind. But the good news for employers is that the Supreme Court disagreed with them and overturned those decisions, so they held that Morrison's was not liable. And this was principally because what the employee did was so far out of line with what he was employed to do and authorised to do, that they didn't think Morrison's should be held liable for it. It was also clear that he had a bit of a personal vendetta against Morrison's, and that was a relevant factor as well. So this is good news for employers, and it means that in certain circumstances it might be possible to avoid liability for sort of pretty serious wrongdoing by an employee. But that's always going to be a question that's judged on the facts. So in practice, it will always be important to ensure that you have appropriate policies and processes in place to try to prevent acts of wrongdoing like this. Right, the final case I'm going to look at is the case of the Independent Workers' Union of Great Britain. This is a claim brought against the government by the union, which is a relatively new union formed to support gig economy workers who are generally engaged as workers rather than employees. The issue in this case is that Section 44 of the Employment Rights Act sets out various elements of protection for employees in relation to health and safety. One element that has got particular attention during the pandemic is the right for employees to leave or to refuse to go to their place of work if they think there's a serious imminent danger that can't be averted. Now, this claim was brought because Section 44 only applies to employees and not workers, and the union argued this meant it did not properly implement the EU Health and Safety Directive. The court agreed with the union. It held that the legislation should apply to workers based on the directive, and that therefore it does not implement the directive properly. So what does this decision mean? Well, workers may now seek to bring claims under the relevant provisions, but our legislation refers to employees, so arguably a tribunal should apply the legislation as drafted. This probably means that a change in the law would be required to enable workers to bring claims, and that means the government will come under pressure to change the law. Despite Brexit happening. We're going to talk about the effect of Brexit in a minute. However, the government hasn't responded to this decision yet, and it may seek to appeal against it. So I think if you use a lot of workers, then watch this space for further developments. Well, that's the end of my updates. I'm now going to hand back to Molly, who's going to discuss some of the top COVID-related questions we've been receiving.
Thank you, Adrian. So we can't get through this seminar without talking about COVID a little bit, but where to start? As Kate said, we've done a little bit of a straw poll of the team and come up with the top 3 COVID questions that we're being asked at the moment. These questions could fill a whole webinar on their own. So this is just going to be a high-level look at some of the key issues. So question number 1, the vaccine is clearly big news, but can I require an employee to have a vaccine? Well, you might have seen in the news that some employers, for example, Pimlico Plumbers, are already making vaccines mandatory amongst their staff, and others may well follow. But in our view, at the moment, mandatory vaccination is likely to be difficult. Clearly, you can't actually vaccinate anybody against their will. So really what we're asking here is whether requiring the vaccine is a reasonable and lawful management instruction, meaning that you could discipline or dismiss an employee who refuses or send them home on nil pay. Now, to answer that question, I think you need to ask yourself why you're considering mandatory vaccination. Perhaps you're hoping to get people back into the office. Well, at present, the law requires everyone to stay at home, and it's only permissible to go to work if you can't reasonably do so from home. There's no loosening of this restriction if your employees are vaccinated. So a mere desire to get people back into the office is therefore not going to be a solid justification for mandatory vaccination. Where employees can't work from home, you might potentially have a greater justification for requiring the vaccine, perhaps on health and safety grounds. But even then, you still need to ask yourself why you're considering mandatory vaccination and balance that against the imposition on the employees. You should already have put in place COVID secure measures in your workplace to protect your staff and others. At the moment, it's not clear whether the vaccine prevents transmission to others, so it may be difficult to justify a vaccine policy on the basis of protecting other people. However, if your staff cannot work in a COVID secure way, because perhaps they have to work with vulnerable people or at close quarters, then again you might have better justification arguments if their refusal essentially limits their ability to work. That being said, vaccination is an invasive medical procedure, and there may be some uncertainty amongst staff about it, particularly in these early days. There's no suggestion that the government is planning to make the vaccination mandatory, and in the absence of a government edict, it's difficult for the employer to set a higher bar. Even the NHS has not got a blanket requirement for their staff at the moment. Looking forwards, we think that the boundaries of what it's likely to be reasonable to ask employees may shift over time as the vaccine becomes more established. It may also be influenced by how the world at large responds to vaccination. You might have seen in the news, for example, that Saga Cruises are going to be requiring all of their customers to be vaccinated before travel. If, for example, some countries start requiring proof of vaccination prior to entry, and you've got staff who must travel to those countries in order to work, then it might be more reasonable to require them to be vaccinated if they can't work without it. We might also see vaccination becoming part of the COVID secure workplace measures recommended by the government, but that remains to be seen. If you do decide to explore a mandatory vaccination policy, then, as with any policy, you'll need to think about possible discrimination risks when setting the parameters. For example, if disabled staff can't access the vaccine for medical reasons, or younger staff can't access it as it's being rolled out on an age basis by the NHS. You'll also want to avoid being too heavy-handed in your approach. Of course, at the moment, the vaccine is not widely available anyway, and is being administered solely by the NHS on an invitation-only basis. Hopefully, over time, it will become more established and more routine. But for now, our view is that employers should continue with your existing practices of encouraging home working and COVID secure measures, even if that's not your preference. There's also much to be said about winning over hearts and minds, and there may be a role for employers to play in ensuring that your staff have access to high quality, reliable information about vaccines to combat misinformation. Question number 2 then. We're planning to allow employees to work from home on a permanent basis, coming into the office only for occasional meetings. What do I need to consider? So while some employers are really keen to get people back into the office, for many others, working from home has had benefits for employer and employee, so you might be reassessing your office practices. If you're planning to offer permanent home working, there are a few things that I would suggest you think about. So first of all, technically contractual changes are going to need to be made with the agreement of both parties. In many cases, especially if you're going to be operating a blend of home and office working, you can probably deal with this informally by notifying your staff of the change and giving them the option to raise any issues with you. If you're planning to close your office entirely and move solely to home working, then you need to factor in time for proper consultation, and you may need formal agreement from your staff. Office closures can potentially trigger redundancy situations as well, even if you aren't reducing headcount, so be alive to that possibility. You'll also need to consider whether you're intending to try and make other contractual changes at the same time, for example, reducing a London salary weighting. Those changes may well prove more controversial with employees. Whilst you can of course change contracts for new staff, for existing employees, you'll need to think about whether you have a contractual right to vary their terms and act reasonably if you choose to do so. It may well be difficult to remove benefits such as a salary enhancement unilaterally. Remember that you still owe duties to protect the health and safety of your workers, especially even if they're working from home. The Health and Safety Executive has got some really useful guidance on this, but a couple of things to think about are the well-being of your staff, especially if they live and work alone, protecting your staff's physical health, especially thinking about screens and workspaces, and of course, your staff's mental health. You might also need to think about how to protect the confidentiality of information and documents while staff are working from home, and think about putting in place more permanent measures to those who might have been operating throughout the pandemic. There may also be some tricky nuances with a move to home working, such as who will bear the cost if the employee has to come in for a meeting. You'll want to establish a consistent approach to these questions to avoid potential differences in treatment. We expect to see a degree of home working becoming the norm even after the pandemic, so it's worth turning your mind to these questions now in readiness for potential flexible working requests. Our final COVID question then. Some of my employees have a great deal of holiday left and do not want to take it as they can't go away. Is this a breach of the working time regulations, and how can I make people take holidays? Well, employees building up lots of holiday can be a concern for employers, both from a welfare perspective and also practically thinking about business sustainability and employee cover. We have a really detailed briefing note about this on our website, but in summary, the working time regulations do allow you to require an employee to take statutory holiday on specified dates, subject to notice requirements. So if you have employees with large amounts of leave accrued, you could consider giving them appropriate notice and requiring them to take holiday on certain dates to use up some of their entitlement. Whether you can do the same in respect of contractual holiday will depend on your contracts. As a starting point, however, we would encourage employers to engage with their staff and encourage them to use up their leave. It's important that employees take a break from work for their health and their well-being, and those benefits should be emphasised to them even if they can't go away. Many employers have implemented systems whereby they're asking their employees to use up a proportion of their holiday by a certain time in the year to avoid too much leave accumulating. Putting in place some structure might help employees to work through their holiday leave allowance and ensure that it's taken. You could also offer flexibility to employees to take a half day here and there, for example, to help with homeschooling. If employees are still resistant to taking leave and you don't want to require them to do so, they may be able to roll some of it over into next year. Normally, most statutory holiday operates on a use it or lose it basis, where unused leave is forfeited. The Working Time Coronavirus Amendment Regulations amended this to allow more statutory leave to be carried forward where it's not been reasonably practicable for the worker to take it because of the coronavirus. This legislation has not yet been tested in the courts, and the surrounding guidance makes clear that employers should do what they can to enable employees to take their leave in the leave year in which it's accrued. The legislation, therefore, appears to be more of a last resort than an invitation to carry lots over. So, in summary, I would suggest working constructively with your staff where they can, and failing that, consider whether it's appropriate to give them notice to take holiday. We've got lots of excellent COVID resources on our website which address some of these issues in a bit more detail, so do check those out for some more information. In a bit of a change of direction then, I'm going to pass back to Adrian, who's going to discuss Brexit and its implications for employment law. Adrian.
Thanks, Molly. And we've been talking about the dreaded B word for about 4 years now at these updates, and let's hope that this might be the last time that we have to. So what I'm going to do is just summarise the employment law implications arising from Brexit, and then talk in a bit more detail about the new immigration system, because that's really the area in which there is some material change. In fact, in relation to employment law generally, the position is really carry on as you are. There are no immediate changes in the law, and there will only be changes if the government decides to change the law. Now, you might have seen recently there's been various press speculation about whether the business department was reviewing worker rights, and some suggestion that they were and that they might reduce them. But the latest is that the business secretary was quoted in the press this morning saying there is no review. That was something that his predecessor had done, but he's stopping that, and there's no intention to reduce rights. So he's now playing the good cop to his predecessor's bad cop, and it obviously remains to be seen whether that stays the position. In terms of the legal position, I've set out on the slide here what the position is. So EU-derived legislation that was in effect by the end of December remains part of UK law. So things like the working time regs, TUPE, discrimination that comes from Europe, they just carry on as they are with no change. In addition, ECJ case law also remains effective, and therefore that will be binding on tribunals and the EAT, for example. But the Court of Appeal and the Supreme Court do have the right to depart from it if they think it's right to do so. What is new is that the UK is not going to be bound to implement any new EU directives that come into effect, and we will not be bound by new ECJ case law. However, any new case law that comes from the ECJ on what was originally derived from the EU could be taken into account by our courts and have some persuasive effect, so that may not be completely sort of out of the picture. And then finally, you will no doubt have heard of the so-called non-regression clause in the trade deal between the UK and the EU. And under this, essentially both sides agreed not to reduce employment law rights below the standard that existed on the 31st of December in a manner affecting trade or investment. Now, obviously, there are going to be questions as to whether any changes in the law do really affect trade or investment. But if one of the parties makes changes of that nature, there's a provision for arbitration between them, and ultimately the penalty is that the other party can impose tariffs. So if, for example, our government did reduce rights in some way and the EU objected to it, the change in law in the UK should still be effective, but it might lead to the EU applying tariffs on goods and raising other complications sort of on that level, but not actually changing the law. So employment law is really stay as you are. Moving on to immigration and the new immigration system that has applied since the 1st of January. Well, actually, it's from the 1st of January for EU people, from the 1st of December to other nationals. We're trying to summarise the position on this slide. So for UK and Irish nationals, there is no change in the current position and no restrictions on working in the UK. For EU nationals who are in the UK by 11 p.m. on the 31st of December, they can remain and work here, but they have to register under the EU settlement scheme by the end of June. And hopefully most people will have done that. For all other EU nationals, freedom of movement into the UK ended on the 31st of December. So they will now be treated as the same way as nationals of any other country and therefore subject to the new points-based system. Under that system, the main way for migrant workers to come into the UK will probably be either the skilled worker route or the intra-company transfer route. I'm going to come back to those. There are a few other specific routes mentioned on the slide, but we haven't really got time to go into detail on those. One point to note, though, is that there is currently no unskilled worker route, although in certain situations there may be scope to bring people into the UK under the temporary worker or seasonal route. In addition, there is an option for visitors to the UK to undertake some business activities under a visitor visa. And you may already be familiar with this, as it hasn't undergone any significant changes. But what this does is it allows an individual to come to the UK for up to 6 months for business, but only to do certain permissible activities, which are quite limited, and that includes things like attending meetings and conferences. But business visitors under this visa are not allowed to take up employment or basically do anything which is akin to working here in a substantial manner. So there are limits to it, but it may well be a route to allow people to come to the UK for short business trips. And actually, EU nationals or EEA nationals can come without a business visa for short visits. So again, there is still scope for EU nationals perhaps coming to the UK for a business trip or to come to a UK site or that sort of thing based just on their passport. So moving then on to skilled worker route. If you're looking to bring people in on a more permanent basis under this route, the key point that is that as an employer, you need to be a registered sponsor. So if you've only sort of had EU migrants in the past and you're not registered, you would need to become registered now, and you would need to comply with the obligations that apply to sponsors. Key question is obviously what counts as a skilled worker? Well, the answer is someone with an appropriate skill level that's at the RQF 3 level or above, and that's equivalent to A levels or above. And it's actually a reduction from the previous rules where the minimum skill level was level 6, which was university level. There's also a minimum salary requirement of £25,600 or the minimum rate for the role if higher. So if the role normally attracts a higher rate, then it's the higher rate. Now that figure of 25,600 is actually a reduction from the previous figure of 30,000. So there's a bit more flexibility there for employers. And there are also some exceptions to the minimum salary, including certain roles on a shortage occupation list. Now the individual must almost have a prescribed level of English and certain level of funds when they come to the UK as well. One new change that is helpful is that previously employers had to meet the resident labour market test, which involved advertising the role for a minimum period of 28 days in at least 2 locations. Helpfully, that test no longer exists, so that's good news and more flexibility, but you do still need to be able to demonstrate there's a genuine vacancy, and that would mean keeping records in relation to vacancies and that sort of thing. So that's the skilled worker route. What about the intra-company transfer route? Well, this allows employers to sponsor an employee from a group company overseas, and this route is largely unchanged under the new rules, so this may well be an avenue you want to look at. I set out the main details on the slide there, so I won't go into too much detail, but under the main route, the employee must have worked for the entity for a minimum of 12 months, unless they earn over £73,900, and the skill level for the role must be normally degree level or above. as we said on the slide there as well, there is also a graduate trainee intra-company transfer route, which allows employees to come to the UK for up to 12 months, and that's with a minimum salary of 23,900. So what does this mean for employers in terms of the new system? Well, obviously you need to be a sponsor, and there will be timing and costs implications in terms of ensuring that people can come into the UK. And therefore, for certain roles, you might want to consider your resourcing strategy. I'm now going to hand back to Molly to talk about some of the appeal cases that are coming up in the next year or so.
Thanks, Adrian. So I'm just going to briefly highlight some of the cases and judgments to look out for in 2021. Now, a number of these cases haven't moved on much from last year, so if you're regular attendees at Hot Topics, you might be getting a touch of deja vu at this stage. You won't be surprised to hear that the courts have been struggling with workload during the pandemic. So first up then, the case of Costal UK and Dunkley. Where there are collective bargaining arrangements in place, employers are prevented by law from inducing employees to cease collective bargaining, and there are steep penalties that apply if they do. In this case, the employer was looking to make changes to T's and C's, but was not making headway through collective bargaining. The employer directly approached their staff and offered them a revised package over the head of the union. This case is looking at whether that approach amounted to an unlawful inducement to cease collective bargaining. The tribunal and appeal tribunal found that there had been an unlawful inducement, but the Court of Appeal disagreed and found for the employer. Hopefully, the Supreme Court will provide some clarity for employers as to how far they can deal directly with employees where there are collective arrangements in place. Secondly, the case of Harper Trust and Brazell. Under the working time regulations, workers are entitled to 5.6 weeks paid holiday per year. So how do you calculate holiday pay for a term time worker who is employed year-round but only works and is paid during term time? At Court of Appeal stage, they said that there was no principle of pro rata holiday where the employee was employed year-round, and her pay should be calculated by reference to the period immediately before she takes leave. This meant that Mrs. Brazell would be much better off in terms of holiday pay than her colleagues who were employed and paid year-round. But there's no legal principle preventing part-time staff from being more favourably treated than their full-time colleagues. The Supreme Court is now going to have a look at the issue, and their decision will be keenly watched by schools in particular. The Supreme Court is also due to give judgment in the long-running Uber and Aslam case, which they heard in the summer of last year. This case considers whether Uber drivers have employee or worker status and are thus entitled to holiday pay, national minimum wage, and other key benefits. The Uber drivers have been found to be workers all the way up so far, so it'd be quite surprising if the Supreme Court changes direction, but we'll have to wait and see. The next case to watch out for is Royal Mencap and Tomlinson Blake. This was heard last year, but the judgment is still awaited. This case is considering whether workers who have to sleep for part of their shift are working whilst they are asleep. The Court of Appeal has previously held that people on sleep-in duties are only working once they are woken up, but not when they're sleeping on the relevant premises. Whether they're working whilst asleep has significant ramifications for their working time and for national minimum wage, so it's going to be keenly watched by the relevant sectors, in particular the care industry. It remains to be seen whether the Supreme Court will agree with the Court of Appeal. In June this year, the Supreme Court will consider the case of East of England Ambulance Service and Flowers, and the question of whether regular voluntary overtime should be taken into account when calculating statutory holiday pay. The Court of Appeal found that it should, and over the years we have seen a steady expansion of the factors that should be taken into account when calculating holiday pay, with many types of overtime already included. So it'll be interesting to see if the Supreme Court continues that trend or puts on the brakes. Our final case in Appeal Watch is Chief Constable of the Police Service of Northern Ireland and Agnew, which is due to be heard just after the Flowers case. This case considers how far back an employee can look when claiming underpayments of holiday pay as an unlawful deduction from wages. There's a 3-month time limit to bring an unlawful deductions claim, so for an employee to claim older underpayments of holiday, they need to establish a series of deductions from their pay, the last of which is in time to bring a claim. You might remember that a few years ago, in the case of Bear Scotland, the EAT held that a series of deductions can be broken where there is a gap of more than 3 months between the various deductions. Now, the Northern Ireland Court of Appeal disagreed with that approach and held that a series of deductions from holiday pay would not be interrupted by a gap of more than 3 months, and that whether the series was broken was a question of fact. Now, this Northern Ireland Court of Appeal decision is not strictly binding in Great Britain at the moment, but once the Supreme Court gives their ruling, that decision will be binding. If the Northern Ireland Court is correct, that could significantly increase liability for historic holiday pay issues. So it's going to be keenly watched by employers across the UK. I'm now going to pass back to Adrian, who's going to take you through our final points.
Thank you, Molly, and I'm pleased to say we are on the home straight now, so well done for staying with us, because I know we're covering a lot pretty quickly. So I'm just going to run through some potential future developments that we think you should be aware of. But I'm going to begin with a couple that aren't new as such, but we thought we were just reminding you. So the first of these is the fact that new regulations came into force on November, which limit the amount that public sector organisations can pay in exit payments. And they limited public sector exit payments to £95,000. So if you're a public sector organisation, you'll need to check whether the regs apply to you. And there is a schedule to the regulations that specifies the organisations that are caught by name or description. And if you are, then obviously you need to comply with them. The next one is gender pay gap reporting. Obviously this isn't new, but it was suspended last year in light of the pandemic. So we wanted to remind you that it would be necessary to file a report by the 5th of April this year, based on information on the snapshot date on the 5th of April last year, if you're caught by the regulations. Also, it appears that if you had any people furloughed on reduced pay on the 5th of April last year, that may have an impact as to whether you need to count them for certain purposes in your report. So it would be worth looking at that carefully. Moving on to something else that is potentially both new and old at the same time, are the changes to the IR35 or off-payroll working rules. Now, these are due to come into force in April this year after being postponed the 2 previous years, unless, of course, the government changes its mind again. Now, we have a video conversation and a guidance note about this on our website if you need more details. In terms of longer term potential developments, there's been much talk of the government bringing in a requirement for organisations to carry out ethnicity pay gap reporting. They consulted on this some time ago, and I think it is likely to be something that the government comes back to. You may recall that the government also previously consulted on the use of non-disclosure agreements and further measures to prevent workplace harassment in light of the Me Too campaign. So we may see some developments in this area in due course as well. A more recent consultation was one that was launched in December, and this is one about restrictive covenants, i.e. non-compete provisions. Amongst the proposals the government is floating is the possibility of non-compete clauses being banned altogether, although another option is the possibility of employers having to continue paying people during the duration of covenants. I think it's probably fair to say there are good arguments on both sides of those points, so it will be interesting to see what the government decides to do, if anything, in this area. Now, you may also recall that before the pandemic hit, the government was talking about extending redundancy protection, particularly for those on or returning from maternity leave. So that may come back onto the agenda over the next year or so. And if you cast your minds back to December 2019, you may remember we had a general election then, and the government issued a Queen's speech which said they were going to bring in a new employment bill in order to enhance certain workers' rights. And one of those also involved bringing in a new labour enforcement body. Now, I know that all seems a long time ago now, but again, this may be something which comes onto the government's agenda over the course of this year. The final point is that there will be the usual increases in statutory rates from April this year in relation to national minimum wage, weeks pay for redundancy payments, etc. So keep an eye out for those. And I think one point that's particularly worth noting is that the age at which the full national living wage comes in is going to be extended to cover 23 and 24-year-olds rather than kicking in at the age of 25. So that will result actually in a much more significant increase for them of 8.7%. So one to look out for, depending on whether you've got people of that age in your workforce. So that brings us to the end of what we're going to say. As we've said, there's more detail on our website in various areas, and we will be sending a handout in the next few days. And I'll now hand back to Kate so that we can answer some of your questions.
Thank you very much, Adrian and Molly. As promised, you covered a lot of ground there. We've had a great number of questions in. Thank you to all those who've submitted questions. I suspect it will come as a surprise to no one that there is a heavy COVID bias towards those questions. So perhaps, Molly, we can start with one for you, if that's all right, if I can find it. Yes, here we are. We've heard you talking about vaccinations, but we've got a question here. Can we require staff to be tested?
Yeah, so I think the considerations with testing are quite similar to the considerations with vaccines, and your starting point is going to be to ask yourself why you want to test people. That being said, I think it's probably going to be easier for an employer to justify a mandatory testing regime versus a vaccination regime, provided you've gone through your thought process and considered your justification for why you want to do that. I think employees are generally a bit more comfortable and familiar with testing, and we're certainly seeing noises coming from the government that they are certainly anticipating testing being a key part of getting people back to work. We've had some of our clients who've successfully instituted their own testing regimes. What I would say is it's probably not for the faint-hearted. You need to think through the practicalities of doing so, what you do with all the sensitive personal data that you gather, the cost, and of course, what you're going to do if somebody tests positive.
Thanks, Molly. Yes, I've certainly heard anecdotally that staff are often quite happy to be tested because if they're coming in regularly, they know that when they're going home, they're not bringing COVID home with them. So actually, some people see it as a benefit. I'd like to pick up on the Marclean case. We had a couple of questions on redundancies. So I'm going to combine them, and perhaps, Adrian, I can be mean and give these to you. So the first one, if we have numerous legal entities, does the 90 days only apply to one legal entity despite people working in the same location? And then the second point is whether or not people need to include voluntary redundancies within those numbers.
Okay, the answer to the first question is that the obligation applies per entity. So essentially you do need to look at it on an entity by entity basis rather than joining together numbers from more than one legal entity. So in other words, if you're planning 30 redundancies, but 15 of them are employed by group company A and 15 are employed by group company B, then neither company is obliged to carry out collective consultation because they don't hit the 20 redundancies within 90 days. So there is a bit of flexibility there, and hopefully that's a helpful answer. In terms of voluntary redundancies, the position is that you probably do need to count them as redundancies because it's generally well established that VRs effectively are dismissals by reason of redundancy. The one situation where you might be able to take a different approach is if you are doing what is normally called a voluntary exit or a voluntary severance scheme, where you're saying to the whole workforce, we need to cut some costs. If you want to put your hand up to leave, there'll be something on offer here. And then you may be able to present it as termination by mutual consent. But if you're targeting it certain areas or you have certain ideas as to the number of roles you're doing, that would probably count as VR, and so it would be harder to achieve. So I hope that answers those questions.
Okay, thank you for that, Adrian. And then the next question is, I think, what we've dubbed the reluctant returner question. And I'm going to do a quick plug, if I may, for our videos. Some of you will know that we've recorded a series of videos which you can find on the Burgess Salmon YouTube channel. And one of those videos looks at this question of the reluctant returner. So the question we've had in is, how would you deal with employees that are refusing to come into the office because they are scared of getting any kind of illness? We're only asking for employees to come in for a business critical reason and for a short period.
Okay, shall I pick up that one? I mean, I think in general terms, obviously, we're not talking about someone who can work effectively from home and do things from home, I'm assuming, in this context, because obviously if they can do what's needed effectively from home, then that's probably what they ought to do. I think what you probably ought to do in this situation is, first of all, understand what the employee's concerns are. Do they have any particular sensitivities or vulnerabilities that may mean that if they were to get COVID, that would have a more significant effect on them? And then you may be able to address some concerns, perhaps by providing their work in a certain place on the site, perhaps ensuring that it's away from others. So there may be some steps where you can give them some assurance as to whether they can come in and be safe, and ensure that it's a reasonable request. Another thing we know some organisations are doing is involving occupational health in that, in terms of assessing whether what the company wants to do is reasonable. And fundamentally, it then comes down to if you can actually be satisfied that you can ensure that it's safe for them to come in and you've dealt with their concerns. Fundamentally, it would be a reasonable management instruction to tell them to come in. And what you do if they don't then come in kind of depends in a bit, because what you might do then is think about whether, if that stops them working at all, you would actually say, well, if you don't come in, then you're not working as you should do, and therefore you're not entitled to be paid. But if it's sort of for a particular event or just a couple of days, it's probably a bit harder, and what you may have to do is think about disciplining the employee there. But if they're still not going to come in, you're going to have to deal with them not coming in and find another way around it, in which case it may be that sort of forcing the issue on a disciplinary basis is a bit unreasonable, but it does depend on the question of sort of degree there, really. I think the first point is assess whether you can deal with the concerns, think about OH, but then it may be that you can require the person to come in and take some action if they refuse to do it.
Thank you. And then we've had an interesting question here, picking up on the point that we were talking about people looking to change working arrangements permanently post-COVID, post-lockdown. So we've had a question: should consultation on changes to working practices, home working, etc., post-lockdown be collective?
I think that largely comes down to how significant the changes are and how much variation, or what rights of variation you've got in your contract. So essentially, there are certain things that as an employer will be within the realms of management discretion in terms of working practices. And then there will some things that will move into the area of being, part of an employee's terms and conditions of employment. So really what you need to do is assess which side of the line they fall. If they're within the realms of management discretion, you may not need to do it. If they're on a contractual basis, you would need to think about it. But then it may be that in your contracts you have sufficient wording that gives you the right to implement those changes. So that's, I think, the process you need to go through. Obviously, it may well be that some form of informal consultation would be helpful anyway. It may be that you can have a more positive engagement with the workforce. And obviously, if you've got recognised unions, then it may well be that you would want to consult with the unions, even if it's on an informal basis, in that respect. But then, if what you're proposing are very significant changes, and they would constitute changes to terms and conditions, it may be that it would be sensible to do selective consultation, because if you had to implement them, perhaps even by terminating contracts and re-engaging people, that does count as a dismissal for redundancy purposes and collective consultation purposes. I think in practice you would do what you can to avoid that, but you would need to sort of think about the process and the extent of the changes and what's involved in order to plan the appropriate approach to how to deal with that.
That's great. Thank you very much. And looking at the time now, that's all we've got time for. Thank you very much for those of you who submitted questions. So a reminder that next week we'll be sending out a copy of the slides and handout together with a recording of this webinar. So you can watch it again if you would like to, or send it to your friends. And of course, it goes without saying, really, if we can help your organisation with any of the issues raised today, please do get in touch. As you leave the webinar, there's a very short survey. If you have 2 seconds to fill that in, I'm assured that's all it will take. That would be really helpful to us. Many thanks for watching, everybody. Goodbye.